Morning, Your Honor. Attorney Susan Cole on behalf of Tyler Morse.
All right, Mr. Morse, state your name, please.
Tyler Morse.
All right, today's date and time set for a pretrial. Let's see here.
Your Honor, I did speak with the prosecutor because this is a second offense. There were no offers. I did discuss that with my client, as well as all of his trial rights that he could have choosing a trial. He's going to waive those and enter a plea of guilty to operating while intoxicated second offense.
Okay. While I'm taking the plea on this one, Ms. Spotch, do you want to speak with your client?
Yes, Judge, thank you.
Okay, Mr. Morse, please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, go and put your hand down. Mr. McCarthy, I'm taking a plea right now. I'm going to move you into a breakout room to talk with your attorney, okay?
Yes, sir.
Breakout room number 1.
Thank you, Judge.
Okay, Mr. Morse, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Have you had a full chance to discuss this with your attorney?
Yes.
And are you satisfied with her advice?
Yes.
All right, you're pleading guilty to operating while intoxicated second offense. That's a misdemeanor charge, carrying with it the maximum possible fine of $1,000 plus costs and up to 1 year in the Oakland County Jail, all at this court's discretion. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Sir, do you understand that once you enter a plea, you give up all those rights that I just said that you'd have at a trial?
Yes, I understand.
And once you plead guilty, there'll be no trial. You understand that?
Yes.
Has anyone promised you or threatened you in any way in order to get you to give up your rights and enter this plea?
No.
It's your own choice to do this?
Yes.
All right. Mr. Morris, direct your attention to October 29th of last year, 2022, where you're operating a motor vehicle on Woodward Avenue in the city of Royal Oak.
Yes.
We stopped by the police.
I wasn't really.
It's a little bit different of a situation. The police, he was, if I may voir dire, Your Honor.
Sure, go ahead.
Mr. Morse, you were following a coworker after a work event where people had some drinks, correct?
No,
Or
I was.
You were kind of I'll rephrase that. Did you see the police pull over a coworker?
Yes.
And
I
then
was.
did
Oh,
you
I see, Ms. Cole.
voluntarily pull over to see and help and assist your coworker?
Yeah, I was. Yeah, I was just trying to see if there's anything I could do to help. It was. Yeah, I was. Yeah.
Okay, I think I got it from here, Ms. Cole. That makes sense. So basically, then you have interaction with the police, and they suspect
Yeah.
that you're intoxicated, correct?
Yes.
Okay, and obviously, having just observed you driving, they then started to put you through some tests.
Yes.
All right, and then they place you under arrest.
Yep.
And then you're transported back to Royal Oak. Is that right? The police department?
Yeah.
And did they have you do a breath test or a blood draw there?
They had me do a blood draw there. I was nervous at the time and wasn't sure what to do, so I refused a breathalyzer. And yeah.
And results, I think, were 0.11.
All right, so Mr. Morse, what did you drink to get to that bodily alcohol content? Was it beer, wine, liquor? What was it?
Beer.
Okay, looking back on it now, with the benefit of hindsight, would you agree that your ability to operate that vehicle in a normal manner was substantially affected by your consumption of alcohol?
Not really. I didn't feel like it was.
I'm not saying then, like how you felt in the moment. All right. My hope would be is if in the moment you felt like you were too intoxicated, you wouldn't have driven in the first place. But I'm saying now, with the advantage of time, Do you think that your ability was affected by that consumption of alcohol?
Mr. Morris, if you
ability to
don't
know.
feel
And
it
if he
was,
doesn't-
then this
if-
matter gets set for trial.
It's well, it not necessarily, because there's no dispute over the 0.11, correct?
Correct.
So it's over a 0.08. If he doesn't believe that he was under the influence, that's just one of the prosecution's theory. So, Mr. Morris, you can be charged with this offense, and the court can find you guilty after you provide a set of facts in one of two ways. If someone is above a bodily alcohol content that's illegal, anything above a 0.08, that's one way. The other way is if someone is basically unable to drive in a normal manner because of the consumption of alcohol. Either one is satisfactory under the law. So if he's not ready to plead to that other theory, Ms. Cole, I'll accept the plea on the high bodily alcohol content, or not high bodily alcohol content, the illegal bodily alcohol content, as long as everybody's in agreement that he was a 0.11. So you'll stipulate to that result, Ms. Cole?
Yes, Your Honor, it was a
And
blood
Mr.
draw. I
Morris,
stipulate to it.
you agree that you were a 0.11?
Yes.
Okay, so Mr. Pasculovich, just giving you a heads up on the Tyler Morse matter. Mr. Morse is not comfortable offering a plea on the theory of under the influence, but is offering under the U-ball, the unlawful bodily
U-ball.
alcohol level. And that's obviously satisfactory for me to take the plea, but I just wanted to make sure you knew that the court is taking the plea under that theory alone at this time, okay?
Yes, that's fine, Your Honor.
All right, and Mr. Morris, you do have a prior conviction for operating while visibly impaired on or about April 11th, 2019 in the 86th District Court in Traverse City.
Yes.
Okay,
And then I did hear the blood alcohol number. That was 0.115. I don't know
Okay,
if I
there's
thought
a-
I heard
there's a blood-
111.
no, it's just, we always said it was 0.11. So there was a 5 at the end of that. All right, so
Yeah.
to the third decimal, we agree that it's over a 0.08. All right, the court accepts that. You agree with that, Ms. Cole?
Yes, Your Honor.
Yes, accuracy is important. I don't mind that at all. So I will order an alcohol screening assessment. Let's see here. My staff will set the sentencing date. Let's talk about those testing times.
Yes, Your Honor. Tyler, I did before you came in mention that we wanted to discuss them, that you, even with the adjusted times, realizing what your schedule and life is like, you told me that you would prefer to test at like 4 a.m. Is that correct? Or
Yeah.
3 a.m.?
Yeah, my sleep schedule is almost impossible for me to manage, and I get a lot of anxiety and end up not sleeping correctly because I'm afraid I'm going to miss these tests. And
Okay, so Mr. Morris, what we've got the 4 times. I tried to adjust it before for you, and
Yeah.
we tried. And I will say this: the court is aware there was a positive screen the day after St. Patrick's Day. Now, it's my understanding that you indicated that there was it was related to your oral hygiene, related to brushing your teeth, things like that.
No.
Obviously, it doesn't look good, Mr. Morris, the day after St. Patrick's Day. So you got to be careful before you're testing. Don't put anything in your mouth. At some point in time, the court's going to have to conclude that something's going on. I will say this: I thought your testing was much improved, much improved. So I have no problem adjusting your times. What times, Mr. Morris, are you recommending or hoping for?
Any times would work for me, as long as like I was hoping to move my 12 a.m. later to like an early morning 3 a.m. or 4 a.m. and if the time out.
You're fine. These are not, so basically we'd go,
I'm trying to find out how it would be.
If we did 4 a.m. to noon, it would be an 8-hour period. Is that what you'd like? Because you told me to try to get to noon, but will you be up always at 4 a.m.?
Yeah, absolutely. I've always had like night shift for a long time, so my sleep schedule, it's terrible.
Okay, I understand. I just want to know what you want, and that's what the judge wants to know. Would be if it was 4 a.m. to noon, that's an 8-hour period.
Yeah, that would
It's
be
enough to
perfect.
get you some sleep, right?
Yes,
Okay, fine. So how about 4 AM, noon, 5 PM, 10 PM?
Yeah.
Okay, all right. 4 AM, noon, 5 PM, 10 PM. And my staff will be in touch with you, Mr. Morse, about the pre-sentence interview, and we'll set a sentencing date. And we'll see you in person for that sentencing. Good luck.
okay, thank you.
Thank you, Ms. Cole.
Thank you, Your Honor.
Okay,